Hi and welcome to Sturm und Rand. In today's video we are going to dive deep into the intricacies of international law and try to answer a very specific question. Did the International Court of Justice, the highest tribunal of the United Nations, actually expose Israel as an apartheid regime? To answer this question, I'm going to explain the context behind the ICJ's groundbreaking ruling about Israel's occupation, what the court actually said, why it is important, and which are the possible consequences of this historical event. Before we start, it is important to explain what the ICJ is and what it does. The International Court of Justice is the highest judicial body of the United Nations, and is usually recognized as the most authoritative institution in matters of international law. The ICJ has two main functions. The first one is to settle disputes between UN member states in a contentious case. This means that when one or more UN member states disagree on the interpretation of an international treaty, the ICJ may be called to arbitrate on the issue. This is, for example, what happened when South Africa accused Israel of breaching the Genocide Convention, a case currently under examination by the International Court of Justice. The court's decisions in a contentious case are legally binding for all UN member states. The second main function of the International Court of Justice is to offer advisory opinions to other UN bodies and agencies. This means that the General Assembly and the Security Council, among others, can formally request legal advice from the ICJ to help them perform their duties according to international law, which is exactly what happened when, on December 2022, the UN General Assembly formally requested an advisory opinion from the ICJ on the issue of Israel's occupation of Palestine. The questions which were asked to the court can be summarized as following. Number one, are Israel's policies and practices towards Palestinians legal? And number two, is the occupation legal? And if not, what should we do about it? On July 2024, the ICJ issued its advisory opinion on the matter and reached very important conclusions. As Reuters reported, the court officially recognized that, quote, Israel's occupation of Palestinian territories and settlements there are illegal and should be withdrawn as soon as possible, end quote. What Reuters and the majority of Western media outlets fail to mention, though, is that the ICJ ruling also confirmed what legal scholars, human rights organizations, and pro-Palestine activists have been saying for decades, that Israel is an apartheid state. To understand exactly what I mean, we need first to take a closer look at the exact words through which the ICJ addresses the issue of apartheid in the occupied Palestinian territories. Quote, a number of participants have argued that Israel's policies and practices in the occupied Palestinian territory amount to segregation or apartheid, in breach of Article 3 of the Convention for the Elimination of Racial Discrimination. Article 3 of the CERD provides as follows. State parties particularly condemn racial segregation and apartheid and undertake to prevent, prohibit, and eradicate all practices of this nature in territories under their jurisdiction. This provision refers to two particularly severe forms of racial discrimination: racial segregation and apartheid. The court observes that Israel's legislation and measures impose and serve to maintain a near-complete separation in the West Bank and East Jerusalem between the settler and Palestinian communities. For this reason, the court considers that Israel's legislation and measures constitute a breach of Article 3 of CERD. End quote. As we can see, what the court did was to present the accusation within the relevant legal framework, namely the International Convention on the Elimination of All Forms of Racial Discrimination, also known as CERD. If you have a keen eye for legal details, you would have probably noticed a big problem here. The CERD does not clearly define apartheid and racial segregation on a juridical level, nor explain what's the difference between them. This has led some commentators to argue that the ICJ did not explicitly confirm that Israel's practices constitute apartheid. And while at face value this argument has some merits, I don't find it very convincing for two main reasons. The first reason is one of substance. The core issue behind the claim that Israel is an apartheid state is the fact that the Zionist entity is accused of being a political project built on institutionalized racism, and therefore devoid of legitimacy. For this reason, remarking that it's not apartheid, it's just racial segregation, is not exactly a very strong counter-argument which addresses the main point of the accusation. But at this point, you may ask, why didn't the ICJ unambiguously specify if Israel's practices in the occupied Palestinian territories can be legally defined as apartheid? To answer this question, it's important to understand how apartheid is defined in international law. In broader terms, apartheid is a particularly pernicious form of racial segregation. Two international treatises clearly defined apartheid in legal terms: the 1973 Apartheid Convention and the 1998 Rome Statute. Since Israel is not a signatory of the Apartheid Convention, and therefore not legally bound to it, the ICJ could not use its legal framework in the advisory opinion. The Rome Statute can be applied to the occupied Palestinian territories, since the State of Palestine is a signatory, but its enforcement is responsibility of the International Criminal Court. And since the ICJ was not the competent tribunal, invoking the Rome Statute in the advisory opinion would have made zero sense on a legal level. The only relevant treaty that could have been legitimately invoked in relation to Israel's apartheid allegations was the aforementioned CERD, since the State of Israel ratified the convention and is therefore legally bound to it. Why do I claim that the ICJ officially confirmed that Israel is an apartheid state, then? Because if we apply the definition of apartheid codified in international law to the official findings of the advisory opinion, it's clear as day that what Israel is doing in the occupied Palestinian territories can only be defined as such. For example, Article 2c of the Apartheid Convention states that the crime of apartheid includes, quote, any legislative measures and other measures calculated to prevent a racial group or groups from participation in the political, social, economic, and cultural life of the country, and the deliberate creation of conditions preventing the full development of such group, end quote. While on paragraph 242 of its advisory opinion, the ICJ finds that, quote, the court thus considers that Israel's policies and practices obstruct the right of the Palestinian people freely to determine its political status and to pursue its economic, social, and cultural development, end quote. This line of reasoning was confirmed by Judge Salam, president of the court at the time, in his official declaration in support of the advisory opinion. In conclusion, how important is this ruling by the ICJ and which are its possible consequences? First of all, even if advisory opinions pronounced by the International Court of Justice are not legally binding, their significance should not be understated. At the end of the day, the ICJ remains the most authoritative source in matters of international law, and its legal recommendations cannot be outright ignored and openly dismissed, like the opinions of a humanitarian organization or of some random UN expert. The ICJ rulings, whether or not they are legally binding, set the standard and guide the development of international law. This is clear if you analyze the rhetoric adopted by the British and German governments, two of Israel's staunchest allies, in reaction to the ruling. Rather than disputing the legitimacy of the legal arguments presented by the court, they claim to respect its authority and, falsely, that their official stance in relation to Palestine is perfectly in line with the ICJ ruling. And since these opinions are highly authoritative in nature, states can legitimately use them to justify their actions in the realm of international relations. To put it simply, the moment the ICJ officially confirmed, among other things, that Israel is a racist state, it provided a strong legal basis for multilateral sanctions against Israel, similar to those who caused the collapse of the apartheid regime in South Africa. Just like Israel, apartheid South Africa was a settler colonial state which displayed utter contempt for international law. It was brought to an end when international isolation and economic boycott made it materially impossible for the white supremacist government to maintain apartheid and its illegal occupation of Namibia. Israel may still enjoy the support of powerful allies, whose geopolitical influence is rapidly declining, but at the same time is highly vulnerable to international economic pressure, which is confirmed by the fact that the Zionist entity considers the BDS movement an existential threat. In September 2024, a UN General Assembly resolution calling for the implementation of the ICJ advisory opinion was passed with an overwhelming majority. The resolution stresses the need to hold Israel accountable for its violations of international law and, quote, confirms its determination to examine further practical ways and means to secure the full respect of the advisory opinion and the full implementation of all relevant United Nations resolutions, notably in case of non-compliance, which could very well hint at the possibility of implementing comprehensive sanctions against Israel. Obviously, I cannot predict the future, but it's a fact that Israel is getting more and more isolated on the international stage, and that this ICJ ruling severely undermines the legitimacy of a state which, unlike apartheid South Africa, does not have the material means to survive long in isolation. And that was all for today. If you watched up until this point, I thank you for your attention. This was supposed to be a short, low-effort video on a very specific aspect of international law I'm really interested in, but it ended up being neither of those things. If, despite that, you found this video informative, entertaining, and in general worthy of your time, and you would like to support my work, you can leave a like on this video, subscribe to my channel without forgetting to activate notifications, and you can also recommend and share my videos with your friends and family. Each one of these actions really help. As you can see, I try my best to produce highly researched, drama-free political content, despite being targeted by YouTube's censorship for my unequivocal support to the Palestinian cause. Despite the abysmal numbers this channel has reached since YouTube decided to demonetize it, I really believe in this project, and your support really helps me to get motivation to upload higher quality content, to upload more frequently, and I really thank you for that. I am particularly grateful to my friends who materially supported me by providing me with books I will need for my next videos. Thank you very much to Ludo and Mariolina, Veronica and Alessandro, Flavia and Andrea, to the other Andrea, and Federello. You guys are the best. Thank you again for watching, and see you next time.